they are something that you should be familiar with, even where you may not be able to handle all of it in terms of implementation or applying it to real life situations. Your awareness alone is sufficient to create, some steps, at least to engender some steps, so that you can look for someone to appropriately advise you. And if we are getting to people asking you to show you or to bring to your awareness these types of provisions, then it means that I mean, there's a signal to the other person that there is something and they must sit tight, I mean, sit well enough to be able to help you. So that is what that is. So we're going to go over this these provision types. Now, there are three types of provisions. The first one, we call them mandatory provisions. Mandatory provisions. That is the provisions that mandates. Okay, those provisions mandate. And of course, there is, so the first important thing is that why do we have mandatory provisions in laws? And then how, at least what are their purposes? And then the second is, how do we identify, provisions that mandate, and what are the repercussions or the significance of having to comply with mandatory provisions. So, mandatory provision in legislation, because those legislation apply to, different people, different settings, to the public generally. It is assumed that some users of these provisions, which in this context would be partners in a business, there's a recognition that some people have, very high bargaining power. Some have very low bargaining power. So to avoid, the cost of having to change or to negotiate, so that the power balance, I mean, the power disparity can be minimized or brought to level between or among the parties, the law imposes those kind of definitions of provisions, so that nobody needs to negotiate around them. Those provisions, when they exist, they bind. And once they bind, everybody, would have to take note of it. As a matter of fact, if you do not apply, if you do not, comply with such provisions, you may subject yourself to punishment, or the agreement itself may be totally void, and you may not want to you may not like an agreement being void after you spent money and stuff like that. So that is one. And also, as I said, it is to protect, is to protect the weaker party in relationships. You will agree with me that in every relationship, power, is never 50-50. It's a relational situation. Some are more powerful in a relationship, some are not as powerful in relationships. And the interesting thing is that from experience, you may start from a situation where your power balance, you know, is, is, is not on a horizontal line, okay? But along the line, there could be a shift in that. The person that was up there before is now low down here. So those things changes. But whatever the case is, when you have a mandatory provision, there is equality regarding the issues that are dealt with. And then they are also infused into laws to ensure standardization. You standardize certain area of laws, so that because the lawmakers have felt that they are good for business, for business and stuff like that. And if experiences show that they are not good, that is why we have amendment to laws, reform of laws, so that after a while, like say 10 years, you really run out or implement a particular law. Government should bring people together, those stakeholders who have been using that law, to come and discuss their experiences, the sticking area, the problematic areas, the good areas, so that they can know, that what else to do by way of reform. This is what normally happens. We don't often revisit our laws in Nigeria, but in other countries they do this regularly because development is always ahead of law, and therefore the government must ensure to narrow that gap. Development is running away, but the law is standing still. I mean, look at where we are today. People, the development we experience everywhere now, and it just the whole world is that everything is technologized. Is handled by technology. Are we negotiating technologically? Are we buying and selling technologically? Do we believe in the workability of that? That is where the law is. It has moved away from analog, and we are still looking at the analog years. Our laws were written in the analog days. We are living a time when, when if there is no digital, instrumentation, it doesn't even make sense. It's not even, I mean, look at what we are doing now. Sometimes, somehow, it's raining somewhere in Lagos. Traffic is very heavy around this time. If I took my car and went to Yaba there, I'm waiting for you. I may not get more than 50 people. Right now, I have over 100. It is because we have a technology to deliver this lesson, and therefore, they continue, particularly with people that are many, and they live in diverse areas of Lagos, and the traffic is not as reliable. You must have technology. Those are the areas where you infuse technology into law, into law, either in terms of negotiation, in terms of compliance, in terms of whatever. That is why all these things are there. Okay. Now, the next one is that I've told you mandatory provisions, mandatory. I'm going to give you, or we are going to discuss how do we identify mandatory provisions. And by so doing, we also, together we identify some of the language. It is not something that is magical. It is just being aware of our English or just the expression that is, and then we interpret it and we can see this one is mandatory, that one is not. Okay. So we start in terms of examples. In every law, there is what we call definition section, or sometimes apart from the definition sections, there are also definition provisions. That is provisions that defines, what the parties must take as given, or a provision that explains the implication of what or the parties have done. Now, those are types of mandatory provisions. Now, the other one, and we're going to go through examples. The other one are those provisions that use the word shall or must. When you are talking about the party shall do something else, that shall means a command. It is prescriptive. It's insisting that this is what you will do. That mandates. You don't have a choice. Because when you are talking about mandatory provision, the choice is taken away from you. The option is taken away from you. What the lawmaker requires is simply obedience. Obey. we will get to the point where option is necessary. But then that is how it is. So you look at a definition of concept. Sometimes the law defines a particular word. That is how the legislature wants it to be understood. And as a result, being a definition, it is binding, or it binds all the parties. It binds all the parties. And it's very important that we bear all of these things in mind. Okay? Now, and so, when you look at this particular legislation, the Partnership Act, definitions are everywhere, and we'll see how we relate to it. So let's go, for example. Now, I want you to look at Section 1, and of course, also look at Section 4. Section 1, what does this say? Let me share my screen so that at least we can have for those who don't have their own system. I'm trying to bring mine out. I'm trying to bring my own out. Okay, let's share. Okay. So I take it that we all can see this now. So we are looking at Section 1. I said, now, this is it. It says, now, partnership, and I hope you are seeing it. Are you seeing my screen, please?
Yes, sir, we are seeing it.
Okay, Section 1 says,
Oh, yes.
partnership
Yes, sir.
Partnership is the relation, and you can also look at your own act too, because I sent it to everybody, really. Partnership is the relation which subsists between persons carrying on a business in common with a view of profit. It's a relationship, that is clear. It has to be a relationship that exists between persons, which means there have to be persons, not just one person. If it is one person, then it is sole proprietorship. We've dealt with that one. But this one, it says partnership is the relationship. You can see that subsection 1 is defining what partnership is, and it cannot be otherwise. So that kind of provision is a mandatory provision. You cannot be in partnership if you are alone. You cannot be in partnership under this law if you are not on business, and you cannot be in partnership with another person if it is not for purpose of making and sharing profit. That is the way it is understood. This type of provision is mandatory. So if somebody is talking to you about partnership, and then it's marriage, it is not business. So that one is social partnership. It does not come under this law. Okay? Yes, even if you are going to do many other things that other partnerships do, for the purpose of this one, the partnership, business partnership, must be for a purpose of making profit and sharing profit. Okay? Now, that is a mandatory provision. Now let's look at then it says, let's look at section 2 also. It says that in determining whether a partnership does or does not exist, regard shall be had to the following rules. Okay, there are so many rules. Now, in determining whether, and these rules are many, we're not going to go through all of them because there are so many other things we want to do. So we can kill some time and cover more grounds. So in determining whether a partnership does or does not exist, regard shall be had. So the word shall shows that when you want to determine whether you have partnership in existence, you must follow all of what that are listed under section 2 because they are mandatory direction, or indicators for purpose of determining whether you are running a partnership or you are not running a partnership. Okay, it's very important. Then I still go to section 4. Again, they are talking about the meaning of farm. Again, defining the meaning of farms to you. So, what does that mean? Persons who have entered into partnership with one another are, for the purpose of this act, called collectively a firm, and the name under which their business is carried on is called the firm name. Okay, so you can see you are a firm, meaning that you are in partnership, and your firm name is also the business name. That is also, a way to identify mandatory provision. When we go on, we see you see the use of the word shall. We still use sparingly. Legislation hardly use the word must, but in this particular case, there are situations where the word must is used. We can bring that out. So, notwithstanding, so these are examples of mandatory provision. What I wanted to take away from here is that one, you understand that it exists as part of a provision type in a legislation that relates or govern businesses or relationship among private people. Now, so that is that one. That is that one. So, and we have also discussed the reason why you have them, the purposes they serve, and we've tried with some examples as well to help us in understanding their purpose, and then in also in identifying them. So just read a section. You can see that they are giving you just the meaning of what they are addressing there without without any empowerment to do something else. It just tells you what is. If you find that kind of definition or section, it is not something you can trifle with. It is given, except there is a way in which the language changes and empowers you. Now we move to the second one. The second provision type is what we call empowering provision. Empowering provision or enabling provision. A provision may enable you to do something. It may empower you. They are the same thing. Empowering, enabling is the same. So, and that one is optional. It gives to parties an option as to what or how they can go about their business or activities. So once you have that, since the law say you may take that route, you take it. If you don't want to take it, nothing spoiled. You can just, so to say. So you can just, move on and do whatever it is that you want to. Now, if you look at from what I discussed, the mandatory provision, if you look at section 5 and you read it through up to the end, you can see, and you can see, certain element of definition that mandates and also some parts of it that also gives allowances. So I'm going to come back to some of this, but let's run through the provision type. So the second one is the enabling provision. When you look at, okay, I've defined enabling provisions to you, is a provision that give parties options on what to do, how to do things. And how do you identify this enabling provision is particularly with the use of the word may. May. When you have a word or a definition that the word may is used, such I mean, such particular provision is an enabling provision. Okay, it's an enabling. It enables the parties that are affected by the law to take some steps to do certain things. So that is enabling provision. Okay, and it is important for us to understand that now. And to be able to understand that if you open your laptop, you can type up the word may and find control F. Just type out the word may, and you start seeing many areas where it has shown up. And you read some of those sections, you can better understand the implication. Now, we are looking at section 17. I have some maze here. So let's go through it and understand it better. Okay. Now let's start from the beginning on section 17. You see, now section 17 says, that's subsection 1. A person who is admitted as a partner into an existing firm does not thereby become liable to an to the creditors of the firm for anything done before he became a partner. This provision, I don't know whether from the we haven't done much with you, but this provision is automatic, binding the parties. It is a mandatory provision. It is this subsection 1 of section 17. It is a mandatory provision, but what it's saying that when you are admitted, anybody that is admitted as a partner into an existing partnership does not become liable to the creditors of the firm for anything done before you became a partner, which is fair. Nobody can force anything on you because you join a partnership that are already in existence, that are already blowing hot and cold, making money, sharing profit, and then they're asking you now to come and be bound to share liability, for what had happened 2 years ago. You just joined. The law says you cannot be liable to the creditors of the business for anything done before you become a partner. So this particular provision is, you can see, that is sometimes, amplifies mandatoriness, except other words are used to indicate that something new could happen. But as it is a mandatory provision. Now, let us now look at subsection 2. A partner who retires from a firm does not thereby cease to be liable for partnership debts or obligations incurred before his retirement. That is like
Please scroll up.
huh?
Please scroll up so that we can see the page.
Okay. So this
Okay.
section 2 is giving you the opposite of what we just read. That other one says that when you join a partnership today, you are not liable for what that partnership has incurred in debt to the creditors if the debt has occurred before you joined. You are insulated. You are protected by law. You don't have to negotiate it, except you agree to be part of the liability you can share, but nobody can impose it on you. And the second one is also saying something that will be of interest to you, that when you retire, you don't cease to be liable from the indebtedness you and your partners create before you retire. It will follow you to retirement. Again, that is a mandatory provision because it does not give, it's telling you what will be, not what may be. It's telling you what will be. And that is why it is mandatory. So the word shall is good. The word is also an indicator, and which means is a secondary identifier of a mandatory provision. Is, that word is, two-letter word, is an indicator of what mandatoriness may be. So when you see it as that way used, be careful, read it again. You see that there is no way to wriggle out of this one. And let's look at subsection 3. A retiring partner may be discharged. I think for the first time we are seeing may, and I told you when you see the word may, there is an empowerment that you have flexibility. You have a choice. You may not do, or you may not make. So it says a retiring partner may be discharged from any existing liabilities by an agreement to that effect between himself and the members of the firm as newly constituted and the creditors. And this agreement may be either expressed or inferred as a fact from the course of dealings between the creditors, the firm as newly constituted. So what this one is saying is that the partners may be discharged. You know, we told you that when you are a partner, you are retiring, you are still bound by the past indebtedness. But subsection 3 comes now and tells you that, that your other people, your colleagues, your former partners may discharge you from those indebtedness. They have the power if they want to. This law is guiding them in terms of what their action could be. So it's giving the retiring people an option. And you can forgive your guy if that is what you want. But to do so, you have to do that by agreement between the partners and the one retiring and the creditors of the partnership. Because the one you are owing is your creditor. Those who owe the debt are the partners. The partners are forgiving one of them that, don't worry, we got this. But you cannot get anything if the person to whom you owe is not part of the agreement, because it has to be part of the agreement. He is the one you are owing, and the nature of your indebtedness to him remains except he frees you. So if he decides to be part of this arrangement, then you are okay. So which means there is a lot of enablement. That is, the existing partners can forgive one of them, leaving them. They may not. That is enabling. And the creditors too, who is the one that wants to be paid, may also join them to say, you know what, if you say you are okay to deal with me, you can go and he will be forgiven. And then in doing so, there must be an agreement. And that agreement also, the law says, may be in writing, express agreement, or it may be inferred. If in the course of dealing with that and with another, we can say that the creditors has actually overlooked it, or the partners have treated the man as having gone, then that is where you infer it. You draw that conclusion from the way parties are dealing with one another. So when you observe how things go, you draw conclusion and you act accordingly. So long as it is reasonable, the law will respect it. That is the word may, explicated properly in subsection 3 of section 17. And as we are doing it, I want you to be following it. I don't want, because I want you to also to be to join and be identifying these things. But we go to the third provision type. I've done two: mandatory provision, enabling provisions, and we are seeing examples. We are looking at examples of enabling or empowering provision. That is what we are seeing right now. Okay. And then let's look at Section 19. I want you to read Section 19 and tell me what provision do you think that is and why? Why do you say it is so provision? And then how do you relate to it? What provision is Section 19? Just give me about a minute or two, I'll be back. But read it, and as soon as I come, then let's quickly address that. But there's still a lot to do. Okay, I'm back. So, Section 19. Let's listen to you. Yes, just unmute yourself and talk to us.
Good evening,
Yes,
sir.
yes, yes. Good evening.
Okay, so this subsection 19, the mutual rights and duties of partners, whether ascertained by agreement or defined by this act, may be varied by the consent of all the partners, and such consent may be either expressed or inferred from a cost of dealing. I think that it's not mandatory in the sense that it is not binding. It was not defined from the beginning of the contract, and it somehow allows maybe things that occur that the partners haven't really thought about when they happen, and allows for, should I say, provision. It just allows where it provides a framework such that then they can customize or find a fit around how something that they did not plan for occurs in the process of the contract when it's binding. I don't know if that is close to it, but it's not a mandatory provision, and it's also not
Okay.
an
Just wrap
enabling.
it up. Wrap it up. I have heard you. You think from what you said, it is not mandatory because it doesn't really impose anything. But I just discussed section 17 with you, subsection 3. And we just discussed that, I believe. Yes, section 17. And there are two occasions in which we saw that one. Even from the little, I know what I have not taught you, but I know what I have just taught you, or I have taught you. So I was expecting that at least you can stand on the authority of what we just heard from me. What did I say may means in any provision of the law? Did I say anything that you recall? Before
Yes, sir.
I
You
excuse
said
myself.
May is yes. It's
Yes, sir.
for
You said, sir, you said May gives the parties options to
Yes, and,
operate,
and yes, any provision that gives party option is called what?
enabling of provision,
Enabling provision or empowering
empowering
provision.
provision. Yes.
That is the other lady, who has the template, but she's not sure, and therefore she keeps saying, or I mean, she wants to explain it over 3 times, you know. Would that show that there's no confidence? Yes, but she has the idea, but she wasn't confident that she was right, because she was right, just that she didn't use the word that because this is May, it gives an option. That's what May does. You may come over if you want to. You may join up if you want to. So which means if I want to join, I can join. If I don't want to, I don't have to join, and there's no penalty. That is what those words mean in real life. And they are no more than what they mean. Okay, so may, when you find may, means it means that it is an optional provision or enabling provision or empowering provision. They mean the same thing though. Okay, because it says, well, let's read it together. The mutual rights and duty of partner, whether ascertained by agreement or defined by this act, may be varied by the consent of all the partners, and such consent may be either expressed or implied or inferred from a cause of dealing. So, therefore, Section 19 is an enabling provision. And the value of this particular provision, is what I will tell you now. Look at the first line. The mutual rights and duties of partners. Defined, that I am using some easy words now, defined by the parties in their agreement or stated by this act by the legislature, may be varied. What is it to vary? What is the other word for vary? Can you give me another one for vary?
Changes.
Huh? Say it. Don't be afraid now.
Maybe change, sir.
Huh?
Differs. Differs.
Yeah, I just say, what is the other word you may use for the word vary? Huh?
Change.
Change. That is all. That is all I want to hear. Change. You see, you can see now that even the things you know, you are not too confident about it. He said it may be varied, it may be changed by the consent of all partners. So, which means, you are still going to run into those laws, and you are still going to do so, and you need to understand the implications of these things. That's why we take time to teach you these things. Many of you will enter into partnership. We enter into partnership. In so doing, or let us enter into agreement, you enter into it. There are certain things that you define your rights and the duties, and you sign it. But this act is saying that the parties may change all of those things, those rights, as you consider at the start. But in order to change it now, so long as all the partners agree to it, it's changeable. Those rights are changeable. That concept express consent or infer
I can't hear anything anymore.
Can't hear you, Sal.
Are you hearing me now? Are you
Yes, we can
hearing
hear
now?
you now, sir.
Okay. So which means if you have defined this particular, your particular agreement, if you have defined your particular relationship, you can change it. But in changing it, remember that this law says that by the consent of all parties. So in a way, this section 19 is mandatory in one sense, and it's also enabling in another sense. Now let me explain to you. It is if you read it again, and I want you to follow me, just that I cannot share now from the major host, and I'm not the major host. That's why I cannot be shutting down
Let the
people.
host make the host.
It's from the faculty, it's not me. Otherwise, but don't worry, we'll get along. Now, let me just, but at least I have sent this thing to you a week ago, so even more than a week. So open your own this thing and let us follow me. So if you don't have it, that is on you. It's not me. Now, now this is how I see it. The first reading, the mutual rights and duty of parties, whether ascertained by agreement or as defined by the Act, may be varied by the consent of all partners, and such consent may be either expressed or inferred from the course of dealings. Now, the fact that the parties have a right to vary their agreement and redefine their duties and their rights is an empowerment. So to that extent, it is enabling. It is optional. They don't need to touch it. The first day you sign your agreement, it remains there. You are not looking at it again. That is your choice. Okay. Now, the second part, however, which which is also which has a mandatory component in it, is that in changing or varying your rights and duty, there's only one way you can do it. You have to consent to it, and that consent must be by all parties. So it is not enough to say majority have said we can change it, so we are going to change it. No majority can say so. Because the law says all the partners, not some, not one, not majority, all. So if you are now going to change the right, if you are in a partnership and your partners now are forming conspiracies or forming groups, and some groups that believe they are larger than you now want to change the rights you have agreed to, or the act has given you to agree to, I mean to bind you, just smile. They are wasting their time because the mandatory component of Section 19 will not allow them. If they do, you will take them to court and they will fail. But many partners don't know all these things we're learning now. They don't even look at it. Even when they go to to lawyers to help them that agreement, they don't remember this thing we are talking about. They just do whatever they can. Of course, if you go to a lawyer who does not know any of these things, and then he's telling you that is it, so are you going to challenge him? You can only challenge if you know better. Otherwise, say, yes, I thank him. So you will thank the person, but it's not giving you the right thing. So that is what we are saying. That is so you have to get to a level when you can begin to dissect these things. Because the changing by consent must be by all partners, not some. Not some. It's just like you want to bring in new partner into the business. New partners that is supposed to be for three of you. What does the law say about bringing new partner? Again, we'll get there. So we will lead that. So the third provision that I want to also let us know, and this one is a very, very critical one. And the reason why we are doing is that there is no way you can make the law serve you except you understand the language of the law. There is no way the law can serve you because they are there to serve you. But you must know his name. You must know the language. Just like those of us or people who are Christians or Muslims, Quran and the Bible, there is a way you make God Almighty serve you or Jesus to serve you in all situations, not just in some, all. But you have to have a relationship and the name because you cannot use somebody you don't know to serve you. And that's why a lot of people invest in knowing Jesus, in knowing the equivalent of Jesus in the Quran. So that they can call him by his name, he will answer him or answer them. Have you ever seen someone who wants to perform magic through Jesus and doesn't even know what name he answers? He has never opened Bible before, no passage, nothing. It won't work. But if you understand it this way, this law, then you are okay, you are good to go. So the third one is the default provision. Default, DEFAULT, default provision. Default provision. That default provision, I'm going to explicate it. I will define it by explication, that is, by giving examples we can all relate to. And then apply it. And after that, after we have explicated it, it is easy to define it because we now know what it means, why it is ever in the law book, and why we must be very careful to understand those ones. They are very critical. Okay, so let's go. Now, when you are dealing with default provisions of a law, I want I want to take you out of this class. Out of legalese. Let us go to the industry or to our social life. Everybody, imagine that we are invited by your faculty, School of Postgraduate Study, and they gave everybody one iPhone for use, and we all have it, including me. Okay? Of course, we're happy, and they ask us we can go ahead and enjoy our gift. When you open your iPhone or any phone, what for that matter, it doesn't have to be iPhone, it can be Samsung, it can be Motorola if you like it. Now, when you open it, what we are going to see first is the default setting, the factory setting. The factory setting. So that factory setting is the one that defines how we may use how we can use that particular phone. It's like a law to us. It is the underlying law for that telephone. Once you open it, the factory setting comes up, and you have to roll by that setting because there is no other setting at that stage. Now, but given our knowledge, which vary from people to people, there are some of us that have been living with telephone since smartphone started in Nigeria. We are familiar with it. We know it in and out. We know it is default setting. We know what it does, and we know what we can do to it. What can we do to it? Now, every phone with a default setting set the basic minimum law that binds every user of that phone. But the good thing is that the manufacturers, and in this case, the legislature, also gives us some empowerment to do what with that empowerment? To change the default setting to to the setting that we want. That is, when you have a default setting on your phone, the phone comes with an empowerment, empowering you to change the default setting to the setting you like. So you now see that we have seen two definition parts now of default provision. Every default provision now, in terms of what I've said so far, has an underlying rule. That is number one. Every default provision has an empowering component. Every default setting or default rule has an empowering component. That empowering component is for the user to change the underlying rule if he or she does not like that rule. Change it to the one you like. Change it to the one you like. Then the third component is that for all phone users, if you don't change your default setting, what it means simply is that that default setting becomes the only way you can use that phone. And that is what we call the mandatory component of a default rule. So you have a rule that we call default setting having three components. The first is the one that sets the rule. And that rule, like a default setting on phone, applies to all. We call it one size fits all. But you know that anything that you call one size fits all never work well for everybody. It will work well for some, it will never work well for others. And it is for the sake of those who will not like it that they are empowered to change that rule to the one that fits their own taste. Because if you have about 100 partnerships, how they came about, their peculiar circumstances will differ partnership from partnership. There are peculiarities. So when you are using one rule to apply to 100 people, you are going to have chaos, hatred, disenchantment. It is to avoid those disenchantment that you are now empowered to change the rule. If you don't change the rule, either because you don't know or the person advising you does not know, then you are bound by the same rule you don't like. So if in the end, that rule you realize now does not serve you, and you now want to change it when at the time when it is late, all you have done for yourself is to create, I mean, is to give yourself a problem, a war. Sometimes these wars kill people, maim people, particularly when it relates to money in partnership. People kill for these things. So you have three partners who have contributed money to do business, you know, with different sums of money. Somebody has put in 20 million, another person has put in 10 million, the third person has put in 5 million. And you do your first year was a bumper year. You made net 50 million profit. And the person who contributed 5 million suddenly wrote to the managing partner, thanking God for a bumper year. Find below this letter my account details. Kindly send my portion of the profit, 10 million naira, to that account. To that account, full stop. And he signs. And I hope you are listening to me. Three partners contributed 20, 10, and 5. The person that contributed least, that is 5 million, is the one writing now that they should divide and distribute this profit equally and then give him his own 10%. His own, sorry, what am I saying now? His own 5 million. Now, and you are asked, and then you wonder whether the person that contributed 10,000, 10 million and 20 million will be looking at the person and honoring it. They will not honor it. They will not honor it. But as you will soon see, the person asking for equality is right, because that is what the law says. The underlying law for partners is that when you are sharing profit and you are sharing losses, you share equally. But that particular section gives you an empowerment to change that sharing formula to the one that fits your situation. Sharing equally or sharing profit equally can never fit the condition of a partnership where contribution is different, is disparate. So, but many partners enter into this without knowing that they can change it to reflect their contribution. They would rather use common sense. And common sense means that, or fairness, and let us divide it equally. According to our contribution. But that is not the law. The law says if you are going to change it to how you contribute, change that equality sharing formula. Change it. So if you don't know because you are not a lawyer, or if you go to wrong lawyers and they misguided you, you will see that the person that contributed 5 million will be the one smiling because he is legally right. So what I'm saying in essence, therefore, is that when you see a default provision, it's telling you that look at this law, look at your own relationship. Does it fit into it? If it does not, change it now. If you don't change it, you are bound by these things. Even if you go to court, the court will rule according to that particular law. You refuse to change because you had the opportunity to change it, but you didn't do it because you don't know. But ignorance of the law is not a defense. So what is then left for the partners except to hurt each other, except to make each other cry in a serious way? So that is why it is very important that we are careful in partnership and we know what we are doing and we are ready to do. And the same thing is there, even in the sale of goods act. If I send sale of goods act to you now, you will also see default provision, plenty. If you open Company Act, you see them plenty, but we don't want to expose you too much so that you can at least have some understanding and not be overwhelmed by what we have here. Okay? Now, let me take you to section 20. Let me see. Oh, I still cannot share. So let us go to section 24, please. But before we go to section 24, I want somebody, or I want us to quickly read section 21 and tell me what type of law is this. So, okay, what I have not done is that I have not itemized to you how do we recognize a default provision? How do we recognize that this is what our guy is saying? This is a default provision. Once you know, then you know you must be doing something. You consider the rule. You ask yourself, where is that rule that the man told us we should look for? Then you know your circumstances. So you can ask yourself the right question. And then once you are satisfied that that rule is not good for you, then you then know the kind of solution. You write it, you change it in your agreement. That is the only thing you need to do. And it's not more than that. Now, so in identifying, there are some phrases that helps us identify that a rule is a provision is a default provision. It goes by saying, unless the parties otherwise agree. Unless the parties otherwise agree. That phrase shows an empowerment that you are about to go into a particular rule which will bind you unless you otherwise agree, or that is otherwise meaning by changing it. Or it says, unless a contrary intention appears. A contrary intention, meaning that something that is different from the rule that you are going to read. Those are the signals. Or unless the parties otherwise agree. Those are the manifestation that you are getting into a default provision. And once you know it is that way, then you know changes may come. It's not compulsory. Sometimes the rule is good. And the reason why those rules are there is because it is difficult. There is the lawmakers would have sat or out of experiences in business or relationships and fashioning out certain areas of relationships that it is just so, just okay to give people relating a minimum rule. But because we know that circumstances of people differ, we must empower them to change this rule so that they don't get stuck into relationship they cannot get out, or they may have to kill one another to get out. But if there is an opportunity to change, why not? They can be happier again, or they can be happy again, or even happier than before by changing this rule into their own, priority or their own circumstances. That is what we call domestication. You domesticate the rule. You make it your own rule. Domesticate it. Okay? So, look at section 21. It's unfortunate I cannot share this screen. So I hope we all have section 21. Are you with me?
Yes, sir, we are following, sir.
So what is how do you describe section 21? What provision type is section 21?
Good evening, sir.
Good evening. Please just speak out a bit louder.
Okay, sir. So I believe section 21 is the default provision. It says that unless
Why do you say it's a default provision? Precious, talk now.
Maybe, sir.
You say it's a default provision.
Yes, sir.
Why? What are the indicators?
The indication there is unless the contrary intention appears.
Okay, that is the empowering component of a default provision.
Provision,
Now
yes.
the rule that you need to know in order to change is the one that follows from the word. You can see that there's a comma after unless a contrary intention appears. Then what follows is the rule. Property bought with money belonging to the farm is deemed to have been bought on account of the farm. That is a default provision. Okay? If you like that particular provision, that rule, starting from property to the word farm, you can leave it. But if you have paid money into the business account in the hope that you are lending them, once the money enter into the bank account of your partnership, it becomes partnership property inside there. So now, if you buy anything with it, the law says that it is deemed that you have bought it with the with the partnership account, and therefore it is the property. Is the pro who is that person? So therefore, it is deemed to be the property of of the farm. However, if that is not the intention for paying it that way, you must quickly change this particular rule in your own agreement. You change it, otherwise you will lose that your money, and there's nothing anybody can do. Because it's not later now, you now want to, when you are now looking at your accounts, you now want to bring this one in when you have kept quiet for the whole year. They will tell you, no, what is it now? But then you start, you start sweating and explaining. You say, please don't bring that since you should have talked now and stuff like that. So again, there will be problems. So that is just that. But then the most important one that I want us to look at is section 24. 24. Now let us look at the opening sentence of this. This section 24 says that the interest of partners in the partnership property and their rights and duties in relation to the partnership shall be determined subject to any agreement expressed or implied between the partners by the following rules. So this one, 24, is talking about the interests of the partners in the partnership property and their rights and duties in relation to the partnership shall be determined by the following rules. I'm keeping something off. By the following rules. And those rules are many. It's like 1 to 9. You see, those are the rules, 1 to 9. If you check your own, those are the rules that will determine the interests of partners in partnership and property and their rights and duty. Okay. Then but the most important is that it will be determined by the following rule, subject to any agreement expressed or implied between the parties. So all these rules are the underlying rules, one by one. But because it is subject to any agreement, you can change it. If you don't change it before problem starts, you cannot change it again. It becomes binding. So some of those rules are okay, good rules. Some of them are not. They need to change. But people don't know. Many partnerships or partners don't know. So they just surrender their lives to these rules until there is money to share, and they realize that it is not convenient, and they now want to change. And somebody said, why do you want to change now? You cannot change it. Please, let us honor this thing. In fact, they will tell you, let us honor this law. This is the law now. You want to formulate your own law. When indeed it is the law which the lawmaker says you can change. But because you didn't know you could change it, you have left it. And the party that is going to take the least money is now arguing that you cannot take anything, you won't change anything. This is where problems start. And it does not matter whether it is husband and wife or brothers and sisters, they fight over these issues, money. And sometimes the fight does not end, just in argument. People lose their limbs, they lose their lives because of this small, small thing we are talking about. That's why it is very important to educate yourself. So what I want you to do quickly, time is going, but I want us to do some. I want you to read, those rules are listed 1, 2, 3. So you will read the rule and will ask, should the partners change this rule, or should some partnerships or partners, should they change this particular rule? Some of you might think, I know it's okay. Some might think, no, they should change it. But you have your reasons. It doesn't matter. So that kind of exercise is fun. The time is running out, but I can hang out with you till 8 o'clock. So let's go. Now, number one, if you are going to contribute, take number one rule and read it out and tell us whether the partner should change this one. The partner needs not to change this one. Okay? I'm coming. Just hold on. I want to be part of this.
So are you still there? I can't hear anything.
I'm here. Sorry.
He said he's coming.
I'm here. I'm back. So who is taking rule one, please? Who is taking rule one now? It doesn't matter whether you get it wrong or just make an attempt. That is the whole essence. In fact, it's better you attempt it and get it wrong. When you are corrected, you know it better. Yes?
Hello, sir. Can you hear me, sir?
Abolaji. Yes, please.
Okay, so for the rule one, it says that
Go
all the
ahead.
partners are entitled to share equally in the capital and profits of the business and must contribute equally towards the losses, whether of capital or otherwise sustained by the firm.
Yeah, so I think that it should not be like that because um we've seen partnership where they don't have equal capital contributed. There's some partners that maybe you just contribute a certain percentage of the capital. So the I think they should not be mandated to, it should not be mandatory that they share capital equally and share losses equally. So that's what I think, sir.
Okay, thank you. Now, I will take your last sentence that you think they should not be mandated. They are not mandated. What you should be asking is that should the partners change that rule or should they leave the rule that way? That's how I want that thing answered. Should the partners change? Having read rule one now, the question is that should the partner, because as I told you, every default provision empowers parties to change the rule. But if they don't change it, they will live with the consequences for not changing it. So the question is, should the partner change that rule? Blessing.
I think they should change it, sir.
Okay,
And
good. That
just
is all I want.
maybe,
No, it's okay. That's what
okay,
I want.
all right, sir.
Yes, that is what I want to hear. That they should change it. And I know you have given the reasons why they should change it because sometimes they don't share equally. Sorry, they don't contribute equally. If they don't contribute equally, there should be the need to change it so that distribution shouldn't be equal. So rule two, somebody has to take that. Thank you, Blessing. Quickly. Yes,
Hello, sir.
go ahead, please.
All right, so I said the firm must indemnify every partner in respect of payments made and personal liabilities incurred by him. A. In the ordinary and proper conduct of the business of the firm, or B. In or above anything necessarily done for the preservation of the business or property of the firm. It should be kept.
So,
Like I feel this rule should still stay.
huh?
I feel it should still stay. It should stay.
Okay.
It shouldn't be changed.
So that is a fair, it's a fair rule. The
Very fair,
parties
sir.
need not change this, okay? That is good. That is good. At least the two speakers have been doing very well. Number three, rule three, yes, somebody else. Yes, someone else. Number three.
So,
Now
a
I will go to
partner
number.
making.
Huh?
Should I go ahead, sir?
Of course.
Okay. So a partner making for the purpose of the partnership and any actual payment or advance beyond the amount of capital which he has agreed to subscribe is entitled to interest at the rate of 5% per annum from the date of the payment or advance. I think that it is not a fair rule. It should be subject to change.
Not that it is subject to change. The question is whether you will advise partners to change this rule.
Yes, they should.
Huh?
I think they should.
Why? Why do you say they should?
Because what if the amount that he subscribed is less than, but for some other reasons he's able to be a partner? That 5% rate is subjective. It can be more or less based on the amount contributed.
Now, what is it? You have to follow the rule. He said a partner making for the purpose of the partnership any actual payment or advance beyond the amount of capital which he has agreed to contribute is entitled to interest at the rate of 5%. I will say that what is missing is that if we all agree to pay, to contribute 5 million, and you have contributed your own, but you are contributing more than, like, say, 10 million. So this rule says that you will be entitled to the interest at the rate of 10 or 5% per annum from the date of the payment or advance. So should the partners change or not, particularly the party that is contributing more? I will say yes, there is a need
It should not be changed.
of interest is about 25 to 27, but they are pegging it here at 5%. So if you are the one paying more, it is incumbent on you to say, let us change this, please. It is not fair on me because I'm actually, helping the partnership by paying double, while my colleagues also do.
Exactly.
So you will be insisting on a higher rate of interest than just 5%. 5% in today's bank loan, it does not exist. So if your own money is 5% interest, then you are losing every day, and they will be thanking you. In fact, they say they will be supporting you in prayers, your partners. So that is good. Number 4, rule 4.
A partner is not entitled before the ascertainment of profits to interest on the capital subscribed by him. I believe that this should not be changed in the
Okay.
sense that they cannot ascertain the particular amount that is coming in on a particular investment that is made. So they should first of all ascertain the amount of profit that is going to be gained before they can say, okay, this is the amount that they are going to share on such occasion.
Okay, because so in essence, you are saying that that rule should stay, right?
Yes, sir.
Okay, because if you have not knocked off all the expenditure, you cannot be declaring profit.
Ascertain the profit, yes, sir.
So it is important to for the partners to be patient to ascertain profit before they can be thinking about interest or whatever it is. Okay, that is fair. Thank you. Number 5, rule number 5. Yes, somebody else. At least we all know that all of these rules are underlying rules, like the default setting of telephones, and that the legislature has empowered each pocket of partners to consider these rules and change them if their circumstances dictate that they should be changed. But if their circumstances fit into this rule, they need not change. So far, your class is doing very well, wonderfully, by making contributions. So, but we still have 3 to go. Yes, number 6.
No, rule 5, sir.
Huh?
Rule
Okay, rule
5.
5. Go ahead.
Every partner may take part in the management of the partnership business. I think
Yes.
the rule should stay.
Why?
Because it has the empowering, enabling provision that says may.
I know. You see, this is a default provision. The rule is that
Yeah.
all the partners must take part in management. What you are to consider now is that suppose you are a part of partnership of 4 people, you have to take yourself into the business world now and see yourself as a participant and ask yourself this question. I am one of the 4 partners. Should we all be partaking in management of this partnership business? Why? Why not? That is the answer I want to get from you, sir. If you say that, yes, it is good for the partnership, why is it good for the partnership to all partake? If you say it is not, what are your reasons? And what do you want them to replace it with? Because this is a replaceable rule. What would you replace it with? That is how I want you to think as a business partner now. Yes.
I think all the parties should be involved in the management.
Okay, you see, the word management is nebulous. It's not defined. If it is a partnership that has different scope, like technical, I mean, like technical partners, some with with the capacity to put everything together, like a managing director, or another one with operations who are very good in logistics. Now, fine. If you say they are going to, for me, I would have said that they may change this rule, particularly if there are different aspects of the business that each party can handle so that they don't cross each other. Then it will be more effective and efficient for them to partner. But if their partnership doesn't entertain that, obviously, issue of money is there, issue of management operation is there. So maybe we want to be in charge of the force. The other one should be in charge of running the operations, and the other one, is doing something else. So that way, they will be working in tandem with one another, although they are covering different areas of the business. That way, their role will influence each other positively, as opposed to say, okay, let everybody dive into it, and then we are crossing each other, we are fighting all the time and stuff like that. So that is how I will see that. But it's okay. Some partnerships they are not that complex to divide it. In some, there are different departments that can be handled if the partners have the expertise to do so. Yes, rule 6. Rule
Yeah,
6.
row six. So, my phone. Jesus, hi. Where's it? Yee. No partner should be entitled to remuneration. I'm trying to look for the sheet, but I know that's what it says. So it's almost like the rule 5. So I think in management there are some, in partnership there are some active partners.
So let me
And
read it. Let me read it out to you, please. No partner shall be entitled to remuneration for acting in the partnership business.
yes, sir. So
Now,
we have active partners and dormant partners or sleeping partners, practically speaking. So we know that some partners are active and some are dormant. So I think this rule should be changed because some partners will be more active than others. So those that are involved in the day-to-day operations should be remunerated, unlike those that are not involved in the day-to-day operation of the business.
Okay. So what is your recommendation?
To change the rule.
Good.
Active partners should be remunerated.
Very good. Thank you so much. So it is important to change this thing so that the man that is running up and down the whole place, tomorrow when there is a lot of bumper harvest, they say equality is fairness. Let us divide it. But if you are using your time to make the money, they should compensate you by remuneration. That's good. Okay. Number 8. No, sorry, number 7 now. Number 7. I don't want to take number 7 out of 120 people.
Number 7, sir.
Yes.
No person may be introduced as a partner.
Hello, Blessing. You have
Sir?
talked, you have answered one today.
Yes, sir.
God bless you. Don't let another person talk, my dear.
Okay. Good evening, sir. I'll take
evening.
number 7. No
Okay, go
person
ahead.
may be introduced as a partner without the consent of all existing partners. I think this law should hold because it won't be right if we are introducing a partner and maybe one or two partner does not know that we are bringing in a new person. So this law should hold.
Okay, thank you. You can see. You guys should be very eager to talk. Not in this kind of 120. How can somebody have opportunity to answer to? Eh? Yeah. The lady almost answered to out of when we have 120 participants. I was afraid though. I thank God Olojede came in because your class is about to scare me. Number 8. I even like the way you guys are responding. You are responding very well. Okay. Number 8. Yes, yes, it is dragging too long. Oh, you should be jumping at this thing. Otherwise, I will tell Blessing to say everything and he will get extra mark. Yes, yes, yes. Any other person? Number 9. Don't worry. All this one you didn't talk about is going to, you will see what I will do. Be keeping quiet. At least I'm noting them.
Can you answer again?
Number
No, don't worry. If you know, just keep it. Maybe your benefit, your reward will come tomorrow. I want your class to keeping quiet.
Number
Okay?
7, sir.
Oh yeah,
number 8.
number 8. Number 8. Yes, 7 is not available. Yes, number 8. Go ahead.
Number 8. Any difference arising as to ordinary matters connected with the partnership business may be decided by a majority of the partners, but no change may be made in the nature of the partnership business without the consent of all existing partners.
Yes.
So I believe that this should hold. It's very
Okay.
valid because hello? Okay.
Yes, finish this
Yes, I
because
believe
now
it should
I'm
hold
listening.
because it's just like the first part of the rule says that some things can be decided by majority of partners, which they can vote to or and decide, but it should not for the major change in the partnership business, all the partners have to be they have to consent to it so that it's there's a uniformity.
Okay, thank you. Number 9. Number 9. Have you, Precious? You have talked today. You spoke today already, Abby. Precious.
Yes, sir, I spoke today already.
Don't worry, Jare. I know you are very hungry for this thing, but don't worry. Let the other
Number 9,
party.
sir.
Okay, go ahead. Have you? No, this man has spoken today, Abby. I want someone who has not spoken so that it can go round. Yes. Now I want you guys to note, write it down, section, not number now, the section. We are dealing with section 24. So, but I want us to go, just write this section number, section 8, section 9, section 10. I want you to write those ones down. And then number 12. Yes. That's why section 12. Yes, not all these ones we are talking about. Now,
Sir, please come again, sir.
no, well, I can't come again. No. When I'm serious with you, I'm hanging this, I'm calling these things. You are not listening.
Sir,
Now,
did you mention 8, 9, 10, 12?
yes, I mentioned all those ones. You are going to work on this one, and as many as you can. There are 3 classification. Um, um, Mandatory, enabling, or default rule. I want you to classify all those ones I'm mentioning. Which type do they belong? You can even do more. You can even do more. You just for you to know and practice. You know, I mean, you and your friends can continue to practice. It does not matter. Okay. Even the ones we have done before today, go over it. Section 17. Okay. Section 17. Then let's see. We have done 24 already. 25, 26, 28, 29, then 30, 30, then section 20, 32, 32, okay, and of course, section 34. So all of those sections I called for you. How would you classify them? Are they default provision? Are they mandatory? Are they enabling? You know, exercise with that, work with that. It's been very fantastic class. I want to thank all of you that contributed and those that listened. Nobody disturbed us today. So you supported the class by conduct. Okay, that is good. Remember section 24, subsection 9. Nobody took it, so I take it that that is an assignment for the whole class. So you can add it to your assignment. But by and large, I want to thank you. It was worth my time to hang out for this 2 hour. It's not even enough, but all the same, we have been able to do. There is someone that is Ayodele. What do you want?
Thank you, sir. I have a question.
Go ahead.
I don't know if I can. Okay, at what level can a default provision be changed?
At what level?
Yes, can
That
a
that
default
it is that it is a default provision means that it can always be changed. Because every default provision has an empowerment to change. And the good thing is that those provisions also indicate by what means or mode you will change it. So you see, except the parties otherwise agree, except a different intention apply, all those things, they tell you how you are going to change it. You must change it clearly. Every default provision is a replaceable provision. The rule is replaceable. You can change it. What you are changing is the underlying rule, and you are replacing that rule with your own that you customize. I hope you understand now.
Yes, but I was trying to ask that at what level, because you mentioned that if problem arises and you are trying to change it, it will not, the court may rule against
Okay,
that.
okay. If that is what you mean,
Yes, sir.
you will, you will, you see, so long as there is no level, so long as you are able to change it before the problem is taken to court. The best time is to get proper advice and reflect on these things as partners so that your agreement is watertight. You reflect on the changeable area and you have changed it, you have customized it, everything reflects your preferences, everybody is happy. Sometimes because you are in a hurry, you didn't think about it. In the middle of the partnership, if that is when you realize that we need to change this thing, you will call your partner to let us change these things because because this law says we can change it and the way it is will not help us or it may not help all of us. Let us change it. So, but don't wait until there's a problem because by the time you have gone to court and there's a problem already, the person that is going to benefit will never agree with you. And not having changed it, if you go to court, the court will be looking at the old rule that you are supposed to change that you didn't change. Okay? Did you Hello, the person that asked me question, where is it?
Yes, thank you very
Right.
much. I got it.
Yes.
Thank you.
I wanted to also say that it was a very intelligent question. I hope you are not in partnership, that you have not changed your rules. Okay, so as I said,
Question.
Huh?
Can I ask a question?
We'll be fast because we have about 4 minutes. Your mic is not working well. Yes. Hello. Hello, Chinelo.
Okay, don't worry about it, sir.
Okay, you already know it. Thank God. So again, I just want to wish everybody a very wonderful night. So it's been wonderful for me, and I hope for you. So keep the work going at home. Don't rest it here, because the time here is never enough. So, but you should be enough for yourself. Create time, work on it, perfect it, reflect on what you've done, and then all the rest. So, good night, everyone.
Good night, sir.
Thank you,
Yeah.
sir.
Good night, sir.
Yeah.
Good night,
Thank you,
sir.
sir.
Good night.
Good night, sir.
Good
Good
night.
night, sir.